seated. Good afternoon and welcome. We have 3 cases on the calendar this afternoon, which we intend to take in the order they're listed. The first case, I believe, is Andrew versus Shands at Lakeshore, Inc. We've allotted 15 minutes to decide. Ms. Creed, you all set? I trust that all of the appellants and the appellees, for that matter as well, have had the workings of the clock explained to them to their satisfaction. I'm not sure I understand how it works, but the good news is I don't have to. So if you want to reserve time, if you're an appellant for rebuttal, you need to sort of keep your eye on the clock, and you need to understand that, for instance, Ms. Creed, now it's set at 15 minutes. That's your total time. If you want to reserve 3 minutes for rebuttal, you need to, at 12 minutes, stop. It's often easier said than done, however. Okay.
I would like to reserve 3 minutes for rebuttal, please. May it please the Court, my name is Rebecca Creed. I'm with the Jacksovnille firm of Mills & Creed, and together with Alan McMichael, we represent the plaintiffs' appellants, Connie and William Andrew. We ask this Court to reverse a final judgment that dismissed with prejudice all of the plaintiffs' claims against an independent hospital, Shands at Lakeshore, under the Sovereign Immunity Statute, Section 768.289A. The trial court relied on this statute to conclude that the plaintiff's only exclusive remedy for all of its claims lies against the University of Florida Board of Trustees. The trial court erred as a matter of law in dismissing with prejudice all of the plaintiff's claims against Shands at Lakeshore for 2 reasons. First, the trial court erred in interpreting the statute to find that this limited sovereign immunity could extend to an independent entity like Shands at Lakeshore. Second, the allegations of the Third Amendment complaint.
Let me ask you a question, because it's not real clear to me, but I assume there's no dispute about it. Shands is, in fact, an independent entity. It's not a governmental entity.
It is not a governmental entity.
It's a private, for-profit corporation?
Yes.
Okay.
And second, the trial court erred in dismissing the allegations of the complaint, which must be accepted as true. And all the relevant allegations of the complaint, when accepted as true, establish that there are causes of action against Shands at Lakeshore. First, the statutory interpretation language. The plain language of the statute limits the liability of an officer, employee, or agent of the state. Here, it's undisputed that Shands is not an officer, employee, or agent of the state. And the statute should not have been extended to afford immunity to an independent entity like Shands. Nothing in the statute extends this language to Shands, and instead it only affords immunity from suit and from liability to an officer, employee, or agent of the state. Shands has relied on the exclusive remedy language of the statute, which is one of the sentences following the first part of the statute. And that sentence states that the exclusive remedy for injury or damage suffered as a result of an act, event, or omission of an officer, employee, or agent of the state shall be by action against a governmental entity. Shands argues that this exclusive remedy means that the only remedy that the plaintiffs have could be against the Board of Trustees. First, this one sentence of the statute cannot be read in isolation. You can't just pick out this one sentence to find that there is immunity for Shands itself. The statute must be read in conjunction with the first sentences of that subparagraph, which state that it provides immunity from suit and personal liability to an officer, employee, or agent. Again, there's case law that holds that Shands is an independent entity, and there have been no allegations to establish otherwise. The exclusive remedy language was added to make it clear that a state officer or employee not only was not subject to personal liability, but also could not be named as a party defendant or sued for conduct that arose within the scope of his employment as a state officer or employee. Before the statute was amended in 1980, it was unclear. The statute read initially as if you could hold the employee, as if the employee was not personally liable, but then that the state would be responsible for any judgment entered over and above the statutory caps. So the legislature cleared that by amending the statute to provide both that there's immunity from personal liability and also immunity from suit. Nothing in the plain language of the statute extends that language to an independent entity. There's nothing that within the plain language that could hold that Shands as an independent entity is entitled to this immunity. The allegations of the Third Amendment complaint establish that there are other causes of action against Shands. We have sued not only the on-call we have not sued the on-call radiologist. We've sued Shands at Lakeshore and the University of Florida. Shands emphasizes one allegation of our Third Amendment complaint, which is that in addition to, or in the alternative to the allegations of the Third Amendment complaint, that this on-call radiologist acted within the scope of his employment of the board. Because Shands has only answered that one count, and the University of Florida has only answered that one count, Shands relies on this allegation to say, well, there's no dispute here. The on-call radiologist must be an employee of the board, and therefore the only remedy that the plaintiffs have is against the board itself. There are questions of fact that are established by the other allegations within the complaint. If you read the entire complaint, there are allegations that the on-call radiologists acted as Shands' servants, employees, or agents. There are allegations that this on-call radiologist was subject to Shands' control and the right to control, including Shands' right to terminate his employment. Again, these allegations of the complaint must be accepted as true. There are also allegations as to Shands' non-delegable duty, and that the Board of Trustees and Shands acted as a joint venture to provide medical care to the plaintiff's child. So there are questions of fact that are presented by the complaint. First, whether the on-call radiologists were in fact Shands' servants or agents or employees, and second, whether the on-call radiologists were acting on behalf of Shands or on behalf of the board when this negligent act occurred. And again, the statute affords immunity to the individual officers or employees or agents, but does not extend that immunity to the joint principal or employer, which in this case is Shands. The Third District Court of Appeal in the Jar decision has a case that is directly on point. And in that case, it's the mirror image of our case. The parties are essentially reversed in that, in that case, the University of Miami is the private entity and the county hospital is the public entity. In that case, just like this one, there was an allegation that the physicians were employed by the public hospital. Nonetheless, the court in that case found that you could not use the sovereign immunity that was afforded to the individual physicians to find that the joint principal or employer, which was the University of Miami, the private entity, was also immune. In that case, the court relied not only on the public policy, but the interpretation of the statutory language and theories of principal and agency to find that just because the agent may be immune from liability, you can't extend that immunity back up the chain to the joint principal to find that the independent entity could also be entitled to sovereign immunity.
But counsel points out that looking at the facts of that case, that that had to have occurred before the statute was amended to put that exclusive language in there, although that is the statute they quoted in the opinion.
That is the statute they quote, Your Honor, and there's nothing in the facts of the Char decision to reveal that it was decided or that the claim arose before the effective date of the statute. Counsel has cited to the Miami-Dade trial docket, but that's a fact that's outside the scope of the opinion, and as this court is aware of the Shaw versus Jane decision, you can't look to facts outside the opinion. Otherwise, you get into a whole debate as to when did this cause of action arise, and it's unclear. So to limit this case to the facts of the opinion is the correct result. And again, there's nothing to show that that cause of action arose before 1980. They do specifically cite and rely on that supplemental 1980 language. The third DCA and JAR relied not only on the same statutory language that we rely on, but also considerations of public policy. The doctrine of sovereign immunity exists to protect the public treasury. And here, Shands at Lakeshore is not a public entity, and any adverse judgment against it would have no effect on the public treasury. So there's no public policy to be fulfilled in extending the sovereign immunity statute to this independent entity. For these reasons, the interpretation of the statute by the trial court to dismiss all the claims against Shands was erroneous. The court should have denied the motion to dismiss and allowed the claims against Shands to proceed, along with the claims against the University of Florida. And I'll reserve my remaining time for rebuttal.
Ms. Kelsey.
May it please the Court, I'm Susan Kelsey representing Shands at Lakeshore, and we urge the Court to affirm. JAR has nothing to do with this case. Even if you don't want to look at the docket and think about how these things work in the real world, even if you don't want to look at that, fine. Look at the face of the JAR opinion. Limit it to its face. Where does the Court discuss exclusive remedy? Yes, they quote the statute because they were rendering the opinion in 1985. That was the version of the statute that was in effect when the decision was rendered. But there is not the first word in JAR construing, interpreting, isolating, or applying the exclusive remedy exclusion that we are relying on today. So you're just going to be putting words in the JAR court's mouth if you interpret that decision as saying anything, one way or the other.
Is there anything in the statute that addresses the liability of a joint principal, not a governmental agency, or the liability of a third party at all?
We believe that there is in the phrase exclusive remedy.
But the first sentence of the statute it says something like that the employee shall be immune. Then it goes on to say that the exclusive remedy, the legislature might as well have said, as between the employer and the employee, only the employee is liable. Now, they didn't say that because some would argue it's just obvious. That's what they were talking about, the liability of the sovereign and its employees, not the liability of third parties. Would we not have to read something into the statute to reach your position? That is, somehow this statute deals with the liability of third parties.
No. You do not have to read anything into the statute because the legislature chose the phrase exclusive remedy. Certainly, the sentence that you just said, if the only players they were discussing here, the only rights they were addressing were those between the agency and the employee, then there would be no need to use a phrase like exclusive remedy.
But don't you have to consider the context in which they use the phrase exclusive? Do you think it would preclude the assertion of liability against a clinic where a doctor volunteers at night? Or how about a traffic accident the doctor gets into in Miami? Could you say, well, I'm not liable because I'm immune because I happen to be a state employee employed with this arrangement by the Board of Trustees or whatever it is of the state of Florida? Or are there some circumstances? Let me just ask the question this way. Are you willing to concede that there are some circumstances in which a state-employed doctor can be liable, that a principal that he works for can be liable? Or do you think that this is kind of blanket immunity? Anything this person does because he happens to be a doctor working for the state, he's immune?
Well, the last sentence you just said is a little bit overbroad, and I know you didn't mean it that broadly. He would have to, of course, be working within the course and scope of his employment as a University of Florida or whatever university
So
employee.
If they allege in their complaint that he was working within the course and scope of his employment for Shands, as an agent of Shands, how does that get past a motion to how does that get dismissed?
Because we are here on a motion to dismiss. The allegations of the complaint are taken as true. Inconsistent allegations can and should be disregarded. If you would never get a complaint dismissed if the plaintiff could always assert A and the opposite of A. So the rule of law in this court's Townsend decision is that you can and should disregard inconsistent allegations because they have a legal effect. They do allege.
Wait a minute. I thought it had always been clear, or at least been clear for the last 50 years, that you can allege claims in the alternative, and those claims can be inconsistent. It's either you're liable to me or you're liable to me. Isn't that all they did here?
You can do that, and that is what they did, but this is a unique situation because of the statute. One of their two inconsistent allegations of fact has a unique legal significance under this statute because it says if you are an employee of the State Board of Regents or Board of, Trustees of the State University or whatever, a state employee, and they did allege that he was, then the legal consequence of that allegation of fact, which must be taken as true for purposes of the motion to dismiss, is that the exclusive remedy, assuming there's no wanton, willful, and so forth, the exclusive remedy is an action against the state agency.
So you can't sue a joint tortfeasor, even if that joint tortfeasor has nothing to do with the state of Florida, as long as one of the tortfeasors is an employee of the state of Florida.
I think that gets into a different set of issues.
Well, isn't that result dictated by the argument you're making?
I don't think it is. That's not the argument.
Why not?
That's not the argument that I intend to be making. It depends on the basis of liability. Is it a sequential tort, a contributing tortfeasor, truly a joint tortfeasor? That's going to be a very fact-intensive question. On the allegations that we have here, the only reason they're bringing Shands at Lakeshore into it is because that's where the patient went. He was an employee of the Board of Regents. He was, sitting in Gainesville. They emailed him the X-ray, and he read it. The only reason they're bringing us in is because we were, in the neighborhood, essentially. We provided a hospital that he went into.
Or because you were the employer.
Of whom?
Maybe.
No. I mean, I understand. That's how they're trying to get around it. Okay, they're saying, okay,
but
joint.
But we're on a motion to dismiss. It
Joint
may turn
employment.
out that it's clear that this doctor is an employee of the Board of Regents. He's not employed by Shands. Shands had no control over him. But those are factual issues, aren't they?
Not where they come right out in the complaint and allege he is an employee of the Board of Regents, which has to be taken as true, and it has a unique legal significance under exclusive remedy. You buy it or you don't, I mean, but that is the argument, and it really does.
I understand your argument, but isn't the ultimate effect of it really to corrupt the concept of sovereign immunity? Because here you have this statute which is designed to provide immunity to the employees, and now we're using it somehow to protect the principle of an employee.
Well, again, you're begging the question of who is the employer.
Well, I'm assuming that what they're saying in their complaint is true. I don't know the answer to that. I'm no longer a trial judge, and I'm not into that. That may be or it may not be. It may be one of those things that on a summary judgment you knock out in 5 minutes. We're not there yet. But where we are now is if there's an allegation in the complaint that says that they are agents of Shands working at the direction of Shands. I think she even said, I don't recall reading this, that they were subject to being fired by Shands. I mean, if there's that kind of control, aren't we not passing sovereign immunity, this protection that belongs to the state, over to a third party, a private entity?
No.
I mean, the state can waive its sovereign immunity.
Right.
But I'm not aware of a situation where it can actually confer sovereign immunity on private entities. I mean, if that were the case, the state of Florida could just as well go in the business of leasing doctors to Humana or some other big. Think about how much cheaper it would be. They just go to work for the state, and the state would lease them back to big private companies.
It may come to that.
Well, but wouldn't that turn the concept of sovereign immunity on its head, is what I'm asking you?
See, it's more than semantics, but we are not claiming sovereign immunity. We are saying exclusive remedy is different from sovereign immunity. Sure, the statute is talking about sovereign immunity, but that makes it all the more compelling that they chose to use a completely different phrase. They know what these words mean. We have to assume that they knew what they were doing, that they meant for it to have effect, and that they weren't engaging in vain repetition. Look at the first two sentences. The plaintiff's interpretation of the statute would have the exclusive remedy and the phrase that comes after it exactly a repeat of the first sentence, including the whole unless, wanton, and willful, and so forth. Why would the legislature do that? I mean, that just violates a very fundamental principle of statutory construction. We are not to presume that they put this in there for no reason, that they engaged in a vain repetition, useless redundancy. It has to be there for a reason. And, I mean, just straight statutory interpretation. You look at the plain meaning of the words the legislature chose to use. It's very significant that they chose exclusive remedy. Immunity, they know what immunity was. Immunity cloaks an otherwise defendant, with some protection of some scope. Remedy acts to limit what the plaintiffs can do. It was an intentional choice of words with a very specific meaning, and it should be given effect. If you deconstruct the statute into its sort of two sections, the first part of it discusses the impact, what is the individual's role? Remember, this was, the late 70s when all of this was new and there was confusion about can you sue them? Can you name them for a defendant? Are they liable? Are they going to be indemnified? If so, how much? So in the 1980 amendment, they addressed that. They put the last, peg in place by saying he's not liable, you're not going to indemnify him, and you can't even sue him.
So doesn't that mean as a practical matter, if we accept your argument, that Shands, all of the Shands entities, and there are certainly several of them now, all independently incorporated, that you can't sue any of those entities ever for professional negligence by one of their employees?
No, that's not what that means at all.
Well, aren't they all also employees of the Board of Regents?
Shands does not employ physicians. They are employed by the University Board of Trustees.
So you could never sue any Shands entity for professional negligence on the part of one of the doctors.
I think that's right. And that's what this statute says.
Haven't there been a lot of lawsuits going on around this state against Shands for professional negligence?
Yes, and there has not been one rejecting this argument, but honestly, it hasn't been raised that much because it's only since the tort reforms, started squeezing the plaintiff's bar that they started reaching out for ways to circumvent the tort reforms. So as they increase the list of the litany of vicarious liability against Shands, the reaction is to do whatever we can to try to stem that.
And in fairness, the other alternative to trying to find ways to get around tort reform is to say trying to find ways to get fair compensation for the injuries of their clients.
Depends entirely on your viewpoint.
Exactly.
I have mine. But, yeah, it has not been adjudicated one way or the other, and our position is JAR did not adjudicate it one way or the other, which leaves the privilege to the three of you. And it's a very simple statutory interpretation argument. It does not mean you can never sue Shands. Shands there are various direct liability theories that you could assert, negligent credentialing, nursing liability, premises liability, a whole litany of them. But there are good reasons to believe that this is what the legislature meant. The plaintiffs say, well, it doesn't, if you sue Shands, it doesn't affect the State Board of Regents. Well, sure it does, because you've got, first of all, the relationship issues, and it's not limited to the board-affiliated teaching hospital context. Think of all the public-private partnership dealings that go on in the state. If you're going to tell these people that the private part of the public-private partnership is suddenly going to be the surrogate deep pocket, why are they there? Why are they there? That's certainly going to chill those relationships. It's going to drive up the cost of those relationships, and it will embroil the agencies in additional litigation. Are they going to try to third-party them in? Are they going to look to them for indemnification? It absolutely affects the state agencies.
Well, isn't the simple solution to make these entities like Shands public entities?
I accept. And yes, that's one way to look at it. And that's something that's problematic about the JAR analysis. I mean, look at JAR closely. It went in bank or en banc, whichever way you want to say it. It came out 5-4, and I think they really had trouble with the contorted analysis that led them to put the liability on the University of Miami. But one of the ramifications that you have to think about is if you start accepting the joint employment concept, that Shands all of a sudden is a co-employer of all University of Florida faculty, physicians, residents, fellows, and students, well, that's certainly a factor that would be relevant to an analysis of whether or not we're acting primarily as an instrumentality of the state. Do we want to go there? If we have to, we will, but that's another reason why I think that JAR just doesn't have anything to do with this case, and this court will be writing on a blank slate.
Well, what did you make of Judge Altenburn's comments? I mean, I thought it was interesting that he wrote in the context of a venue issue, wrote about the dangers of this kind of arrangement. I think he said the state was essentially selling its sovereign immunity to private industry. I mean, a private company like your client gets a competitive advantage by getting the benefits of something that is supposed to belong to the government.
I won't directly tell you what I think of that.
Well,
but,
okay.
He did say that. He was
and
my case.
by the way, he was primarily an insurance defense lawyer when he was practicing.
Yeah. He's really gone down. Yeah, it was interesting.
I mean,
it was not an issue in that case, which made it more interesting.
A good point there, or raised an interesting concern, don't you think? I mean,
yes.
Would you want to have competitors who gain well, maybe you are one, but I mean, do you want to have competitors who gain an advantage by going into partnerships with the government and getting the protection that is supposed to belong only to the government?
Right, and if I could, I know my time is 4 seconds. Let me just sum up very quickly. His comment, the flip side of his comment, and there are two sides to the story, and it's the sun chasing the moon, or the moon chasing the sun. The flip side of that is, of course, that in these outlying counties, which is where the Morris case arose, like this one, the university is doing a public service by staffing, providing a couple of emergency room doctors in these remote counties where nobody else will go there. They can't get, competent people to go or stay. So, there's policy considerations on both sides. If you say don't go there if they're going to be immune, then they don't go there, and then they don't have anything. So there are policy considerations on both sides. We appreciate the court's consideration and ask you to affirm. Thank you.
Ms. Creed?
May it please the Court. First, the Jar decision is not distinguishable. The same types of arguments were made in that case as are made here. The private entity was seeking to extend the immunity that was granted to the agents of the state of Florida. Second, the exclusive remedy language, the state can't be sued for the negligence of an employee if the negligence occurred outside the scope of that employment, or if the employee acted in bad faith or willfully and wantonly. So the very fact that the question as to the scope of employment is an issue.
Could the doctors themselves be liable in this case if you prove your allegation that they were actually working for Shands?
They could. And that is a question of fact that has long been held to be a question of fact in other cases within this district. The Martin versus Driley case, for example, that was a case where it was a faculty member of Shands, a surgeon at Shands, a faculty member at the University of Florida, and there was a question as to whether he was acting within his scope of employment, whether he was wearing his Shands hat in performing surgery, or whether he was wearing his University of Florida teaching hat. And in that case, the court said that's a question of fact. That's an issue that needs to be resolved. And in that case, even was a summary judgment issue, and there was enough of a question of fact to reverse that. Here, we're on a motion to dismiss. There are allegations within the complaint, again, that state this was an on-call radiologist. He was performing a service for a Shands patient at a Shands hospital. He was using Shands equipment. The references to reading it by email, and none of that is in the complaint. It is the complaint itself that this court is limited to. This court is absolutely right that you can allege claims in the alternative. And the allegations against the University of Florida state, in addition to or in the alternative to the allegations above, at all times for material hereto, the radiologists who interpreted the scan were the employees of the University of Florida Board of Regents. Again, you can find that the radiologists were acting on Shands' behalf. You could find that they were acting on the University of Florida's behalf, or both. Certainly under case law, you can have more than one principal or employer, and you can share liability for the same injury. So the allegations are not inconsistent. There are also allegations as to a non-delegable duty theory, and to that extent, Shands can't escape its non-delegable duty to provide non-negligent medical care, even if the radiologists were independent contractors. So with the allegations of the complaint as to non-delegable duty, the allegations that there was a master-servant relationship between Shands and the radiologist, that Shands had the right of control, that the radiologists were using Shands equipment and performing the service for Shands, there's certainly enough of a question of fact to find that there's some issue as to whether they, in fact, acted within the course and scope of their employment for the board or within their course and scope of employment for Shands. For all these reasons, we would ask that this court reverse and allow the claims against Shands to proceed. Otherwise, Shands keeps saying that they're not seeking sovereign immunity, but at every turn it seems as if that's exactly what they're claiming, that they're seeking to extend this statute to an independent entity. And clearly, Shands is not a state agency and shouldn't be entitled to rely on that sovereign immunity. Thank you.
Thank you. Thank you both. That was an excellent argument.